to all my fellow speakers, to Raji and Bill, thank you for opening this conference with absolutely insightful remarks. It's very difficult to follow that. And I'm thankful also to Father Shad for her remarks as she set the stage for a lot of what I'm going to discuss this morning. The present sanctions and designations regimes and their implementation in social media platforms inhibit conflict resolution, diplomacy, and the provision of humanitarian aid, something that we are seeing first and foremost in the situation in Palestine. They also interfere with the ability to conduct atrocity investigations, document evidence of war crimes, and promote post-conflict reconciliation and the creation of historical truth. Important voices are being silenced because of these regimes. As a sanctions in a nutshell, because this is an extremely complex legal topic, sanctions are a means by which countries or the UN can seek to compel or deter behavior by imposing broad restrictions on a country or targeted sanctions or designations of individuals or organizations. These can be arms embargoes, trade restrictions, asset freezes, prohibitions on transfers of arms, criminalization of material support or association, something we see especially after October 7th, or visa or travel bans. Licenses may be general or specific, crafted to allow for humanitarian aid or other services. Sanctions occur under a number of areas: terrorism, organized crime, and most recently global Magnitsky, focusing on individuals and entities responsible for the most heinous human rights abuses, atrocity crimes, and war crimes. And as our dear friend Raji noted this morning, sanctions can also occur against prosecutors and investigators at the ICC for seeking to document, investigate, and prosecute the United States and Israel. So why are sanctions and designations so problematic in armed conflict? As Shah had started to discuss, terrorist designations in armed conflict present unique concerns. The label is imposed absent a universally accepted jurisdiction and definition, and often gives nations unlimited powers, unlimited resources, and measures that go beyond what international law allows in order to, quote, fight terror. Sanctions are also a tool of propaganda, often applied unilaterally, yielded to shift the power balance in armed conflict. Consider the historical debate of terrorists versus freedom fighters, how Nelson Mandela was viewed for years. Sanctions are also an economic weapon, a means and method for third parties who are not directly involved in hostilities to impose limitations on the ability of one party to procure arms, but also restrict access to financial markets or even civilian supplies. Innocent actors who would seek to negotiate peace or lay the foundations for negotiations and post-conflict reconciliation face barriers to access and risk of prosecutions for providing material support. Sophie Haspeslaw's book, Prescribing Peace, is a groundbreaking effort looking at this as it pertains to Colombia, and we must build on that work. Despite exceptions or exemptions, sanctions are limiting and preventing legitimate humanitarian operations during armed conflict, leaving vulnerable populations more dependent on the sanctioned actors. And finally, we have the problem as to what happens when a prescribed group becomes the state authority or de facto rule of a country. What impact does this have on diplomatic negotiations, economic pursuits, but especially on the people under its rule? An aspect we've encountered with the Houthis in Yemen, the Taliban in Afghanistan, Hezbollah in Lebanon, and Hamas in Gaza. Hamas has been designated by the United States as a foreign terrorist organization since October 1997. At the same date, the US also designated the Palestine Liberation Front, Palestine Islamic Jihad, and the Popular Front for the Liberation of Palestine. As far back as 2006, the United States also included the Palestinian Authority as part of OFAC's terrorism sanctions program, finding that Hamas has a property interest in the transactions of the PA. By this, it means that US persons, broadly defined to mean more than just human beings and more than just those physically present in the United States, are prohibited from engaging in transactions with the PA unless authorized by the US government. Notably, even the Palestinian Water Authority and government-owned or controlled universities in the West Bank or Gaza fall under this sanctions regime. Since 7th October, the US and the UK have released 4 additional coordinated sanctions actions related to Hamas, as well as in the EU, Canada, and a special focus on financial networks and facilitators. However, despite the ongoing genocide and war crimes committed by Israel, the only sanctions imposed on them are against a few violent settlers in the West Bank. So let's take a step back for a moment to understand, to be an FTO, a foreign terrorist organization, there must be a finding that the group is a foreign organization and engages in or intends to engage in terrorist activity. And this activity must threaten the security of US nationals or the US national security. This allows for asset freezes, material support prosecutions, visa denials, or travel bans. The US government has extraterritorial jurisdiction and can criminally prosecute any individual or entity that provides material support, very broadly defined, to a designated FTO. And there are examples of the misuse or application of these laws in humanitarian settings or merely providing innocent family support. The UK has similar laws, something that we have seen being used against protesters or anyone who seeks to speak in support of Palestine. The FTO designations also allow for US persons to pursue civil liability for those who are deemed to provide substantial assistance to an FTO. There have historically been civil lawsuits filed in the United States, and in the last 4 months, we've seen a number of new lawsuits being filed against entities allegedly supporting, whether through public statements or fundraising efforts, alleging that the support is for Hamas. These broad-reaching and serious consequences go beyond just the entity that's been targeted by sanctions. FTO designations thus have a devastating impact on those seeking to provide humanitarian aid, as often NGOs and others are unable to negotiate this complex regulatory landscape or are hesitant to provide financial resources out of risk of criminal prosecution. NGOs also are facing hurdles in accessing financial institutions through debanking and de-risking, many times solely based on the fact that a bank will not allow a charity even to open a bank account if the country they're working in has FTOs operating within it. These designations also have a devastating impact on peace prospects. Governments and private actors may be hesitant to engage in peace negotiations or make deals with these, quote, terrorists. And third parties face extensive hurdles simply for having discussions or providing advice to these groups, even if their end goal is to remove these groups from power and bring about an end to a violent armed conflict. So this leads to the second part of my presentation, which are the challenges of what I call social media sanctions. And what has emerged from the siege and what we've seen happen on social media is the question of whether reforms are needed as social media content moderation policies are modeled after government sanctions lists and designations. Many here likely heard the reports of accounts being banned or suspended on Meta's platforms, shadow banning of content, or the outright removals and censorship. Whilst corporations are not bound by free speech principles or the First Amendment, even though most of the platforms are in the United States, provisions with international treaties and human rights norms do guide what these platforms should be doing in this context, especially during armed conflict. Content moderation and bans on terrorist groups on social media platforms evolved from the time in which Al-Qaeda and Daesh were engaging in propaganda and recruitment online and on the platforms. Out of pressure from the US and other countries, including threats of legal liability, social media companies implemented policies and community standards that governed who had access to the platforms and what they could say. In exchange for this, these platforms also allowed many governments a backdoor in order to gather intelligence, information on users, and respond to government requests to take down content or shut down accounts. I do not say that platforms do not face a difficult decision in this. They're looking at rights to free speech and expression, legal compliance and liability avoidance in terms of their responsibilities to shareholders, and governing the pressures exerted on them by governments with threats of liability. However, we must also look at the impacts on diplomatic and political communication in a new world, whether between citizens and their governments and the right to speak about the issues that present them, between governments and diplomats, or simply between citizens themselves discussing the issues that are plaguing their society as one important aspect of the peace process is the on-the-ground discussions and reconciliation between individuals. But finally, the role of social media as a news provider, especially when international media outlets may be government-controlled, censored, or completely banned, as has occurred with Al Jazeera. In recent years, social media platforms have been a vital resource for those documenting war crimes and human rights abuses, including open source intelligence investigations by entities such as Bellingcat, the Yemen Archive, and a multitude of organizations investigating war crimes in the Ukraine-Russia conflict. Meta's oversight board, its appeals body, and the one who provides recommendations for policy reform for Meta, repeatedly recognized that Meta has, and I quote, a responsibility to preserve evidence of potential human rights violations and violations of international humanitarian law for purposes of investigation, documenting pivotal points of history, and assisting with accountability efforts. Yet since 7th October, we have seen widespread censorship and content removal on the platforms. We must ask then, does content moderation allow governments to use social media platforms to censor speech to serve their own diplomatic and political interests? Or are corporations just acting in their own self-interests of profit, public relations, and their own image? Are they allowed to do things that a government would not be allowed to do if it was acting on its own? Interestingly, Meta claims that it is legally compelled to censor mention of groups designated by the US, but legal scholars have challenged this interpretation of sanctions laws. Aside from my own opinion, the Brennan Center for Justice called this claim, quote, fiction. Human rights organizations such as Access Now and Human Rights Watch and various journalists have investigated Meta over the last years, with multiple findings that Meta systematically censored Palestinian voices. Employees have resigned and leaked documents exposing what Meta's policies were. Since October 7th, Human Rights Watch documented over 1,000 cases in which Meta removed peaceful content expressing support for Palestine from over 60 countries. But this is not a new problem. In 2021, following the suspension and banning of accounts, suppression of hashtags, and removal of content on the Sheikh Jarrah protests, Meta claimed it was a technical issue. But a third-party investigation found that over-moderation of pro-Palestinian content was due to Meta's implementation of their own FTO policies, and that the problem grew given Hamas's role as a governing entity in Gaza. So even a citizen post or comment regarding day-to-day government operations could be subject to moderation for simply mentioning Hamas. Notably, in 2020, a report revealed that Meta erroneously deleted non-violent Arabic content 77% of the time. The Wall Street Journal found that after October 7th, Meta manipulated its filters and algorithms that they used to automatically moderate, delete, or hide content. Their normal algorithm is 80%, meaning they need to have an 80% certainty that the content is in violation. Following October 7th, any content originating from Palestine had an algorithm percentage of only 25% certainty in order to be removed. Forbes revealed that after October 7th, Israel asked Meta to remove over 8,000 posts related to the events on October 7th. Thus, and that Meta complied with these requests 94% of the time. Thus, while Israel may not be able to prosecute and imprison many of us around the world for what we say and for our attempts to expose the genocide and ongoing atrocities, they flex their muscles and influence on social media platforms to place users in Meta jail and subject them to restrictions or potential bans for reporting on atrocities. But it's not just everyday users, citizen journalists, or activists at risk. Meta even went so far as to remove news media posts about the Malaysian Prime Minister's visit with Hamas in attempts to negotiate peace. Meta's policies on designating actors stem directly from the US FTO lists. This list is secret, it's not made public. There was one version of it leaked in 2021 and published by The Intercept. An examination of this showed that Meta's policies aligned almost exclusively with US designations of terrorists. However, these policies have two separate sides. There's a terrorist designation, which was reserved almost exclusively for groups originating in the MENA region, targeting Muslim populations. Their other list, which is subject to less restrictions, was reserved for right-wing groups and others. There have been two important decisions from the Meta Oversight Board on this, which give us some hope. The hostages kidnapped from Israel and the Al-Shifa hospital decisions. And I'll just briefly, to close up, state that in these decisions where Meta reversed the removal decisions, they said that Meta's temporary measures lowered confidence threshold and increased the likelihood of mistakenly removing nonviolent conflict. They noted that the fact that social media serves an important journalist function, especially where journalist sources are subject to physical attacks and where news reporting by ordinary citizens is vital during armed conflict in situations like this. Something that, given that over 150 journalists have been killed by Israel since October 7th, we must have these platforms to share news. Although the board reversed these decisions, this occurred months later and resulted in a significant time period where important voices, documentation, and news sharing out of Palestine was silenced. So the present conflict demonstrates why these platforms must reform their policies and why pressures must be placed upon them to protect the voiceless. Statements or descriptions of armed conflict should not be banned simply for noting a group. Meta has gone to an extreme beyond what international law allows. But we cannot simply blame the platforms. We must look back at the designations that governments place in the first place and the sanctions regimes that are unilaterally imposed during armed conflict and reform those. There's quite a bit more on this topic, but I hope that today I've at least touched on the issues, raised some important questions, and inspired all of you to start to influence in future legal debates and policy reforms. Thank you.